Welcome to another episode of Judgment Date. As you know, we've been doing these programs for some while during the lockdown to assist people to try to make sense of the medical, legal, and general economic questions that have arisen as a result of this unprecedented situation. Today, we're enormously privileged to just slightly change the tune to some extent, because with me is the Deputy Chief Justice retired, Dikgang Moseneke, who has written his second of two books that he's written about his life. The first, My Own Liberator, which if you haven't read, you should. It's an utterly remarkable book. And then a book which you probably can't see, or maybe you can, called All Rise, a Judicial Memoir, which tracks his legal career. And there's so many issues here, Dikgang, I'm not quite sure where to start. But let me start with the following. If life had taken a different course, I think, as I understand from page 1, you would have been a traffic cop or something of that sort.
Yes, that is my aunt quickly said, no, son, you have to shoot for hire. You've got to do better than that. And there I was, I forgot about the idea. But I guess there was always that little thing of directing people and traffic and ordering them around. So there was some allure there that quickly faded.
We'll come to your role as a jurisprudential traffic cop in a moment. But what I was also intrigued about was that you also had ambitions because of talent at school to go into mathematics. And does that, I know that obviously when you detained as the youngest prisoner on Robben Island, that facility sort of closed off and you did law, for which those of us in the legal community are extremely grateful. But have you thought about that over the years and thinking, if things had been different, I probably would have been a professor of mathematics or something of that sort?
Oh, yes, indeed. I thought, remember that at the time, one of the obvious cop-outs from, the tragedy of apartheid, from the class and race oppression and cultural oppression, was to become a doctor. You set up your own private practice or a GP locally, and they normally drove big cars and they seemed to have the prettiest wives and the biggest houses and so on. And I thought, okay, if you don't want to clash with the system, become a doctor. And many people did who were bright. So I made sure that my maths and science were out there. And that is why I would have either become a professor of mathematics, maybe, or of science, Alternatively, I would have become a GP and later on perhaps specialized. I may well be in the wards now, trying to fight off the pandemic.
Yeah, like we all are. And I wanted to move to the fact that, because I'm just trying to do it sequentially, in your book, when you do say that you then basically did the correspondence degree through NISA when you were on Robben Island, and you comment about, I thought very interestingly, about the syllabus that you encountered and the sort of conservative nature of the syllabus, the Roman Dutch law, the colonial past, etc. I mean, now that, you rose to the Deputy Chief Justice, and as you say quite rightly, and I noticed because I've been to some of them, you gave a series of lectures, extracurricular lectures, and you've had many, many clerks. I mean, do you think we've really, to some extent, have we risen to that challenge that, the young Moseneke being encountering a kind of almost alien legal terrain, which, as you say, I had to get through because that was the deal in order to become a lawyer. I mean, when you speak to young students today, do you feel that they still kind of feel that, or that things have changed so dramatically that the sort of your observations then have essentially dissipated?
Well, Dennis, you remember that there was a whole move towards notions of decoloniality. People been disappointed with the transition and thinking afresh, what were the fundamentals that we sought to irreversibly change? And that's really what a revolution is, isn't it? Is trying to materially transform a horrific, oppressive arrangement in favor of one that actually releases our best potential. In its best senses, that's what a revolution is. Now, many young people failed. And young professors, at some of the law schools, felt that nothing had actually happened. So there's a whole debate about decoloniality. What were the impositions? What are they? And I tell them what I encountered as a young person. When I started studying, they said to me, sorry, you want an LLB, you must pass Latin 1, you must pass English 1, and you must pass, you did that too. You must do Afrikaans, Netherlands 1.
Afrikaans too, yeah.
And in the book, I say, but why do they have those demands? But also because the law would be accessible only through these foreign languages. And then why so? Of course, because the law and Roman Dutch law and so-called common law was common only to the extent that it was common to the colonial power wielders. And there's nothing common about it with its subjects. But the subject had to bow to the law which is now later called common to everybody. It wasn't, not by any means. So I'm just making the point that even that young, I could sense that this was a colonial imposition. That's why you had to learn Latin. That's why you had to learn Afrikaans or English and so on. And two, that it is fair to acknowledge and know and understand that. You say to me, do young people still feel the same way? And the answer, in some circles, thoughtful ones, yes. And the contestation you see in the book is it common law or laws that flow from constitutional principles? And that contestation is very much the same contestation at one stage between the SCA and the Constitutional Court. And when Arthur came, you saw in the book, bursting out and say, there's only one law in this place, not two laws. So I'm trying to track that and trace that and that tension. That was inevitable to say some held on to Roman Dutch law and common law as the only law that ought to rule the roost. And yet, if you recognize that in fact this was an unwelcome imposition, you tread much more softly. And we tended to look for sources of law from the Constitution and its high values. And when the common law is good, of course you uphold it. So yes, I think there are young people who are debating what are the things that we may usefully move away from in order to alter the power relations in our society.
So on that point, because you talk later on in the book, and certainly as somebody who's been on the bench, I can well understand that the invigoration of the real debate that one's having, both with oneself, one's colleagues, and counsel. I perfectly understand that, more than understand that. That's the best part of the job. What I suppose I'm interested in is you yourself have written about transformative constitutionalism. You imbibed it in your judgments, but you also wrote about it extracurrially. And in 1998, Carl Clare wrote a famous article. And one of the things he said was that he was worried that the conservative South African legal culture would restrict, as it were, the transformative project, constitutional project. Now, as somebody who sat, for the High Court and then the Constitutional Court for many years, do you think that actually the legal profession has risen to that challenge? I mean, probably more so in the Constitutional Court than anywhere else, but since you've read records of courts as they come up to you, I'm just intrigued by your perception about whether you thought that the profession has embraced the sort of, if I could call it, the visions that some of the members of the Constitutional Court did in their judgments.
The answer is no, Daniels, and it's patchy, of course. It's not an outright no. Look, in the book, I plan to spend some time to show that in the early days, even the judges of the Constitutional Court who sat there have this notion that you reach constitutional law only if common law cannot get you there. And you see how I'm critical about the Kentridge judgment in the early days about don't get there unless you have to get there. Now, which meant that the constitutional law was some foreign imposition, which you use only in desperation, but not as a starting point. Carl Clare, as you know, I admired. In my own transformative adjudication paper, I draw from him, I draw from your writings quite lavishly. And here's the point. my notion of our Constitution and its arrangement was a social democratic one. I think it was a conscious and very valiant attempt to actually transform the power relations in society, to change what we were to what we hope to be. And that you do by bringing laws that seek to do that. And if one recognizes that apartheid, besides is capital accumulation underpin, and which is an underpin of colonialism after all, you would also understand that it had a whole bunch of exclusions that went together with that white male toxicity. And those were, for instance, being, homophobia, oppression of women. I mean, there were 2 judges or something by 1994 who were white, so they wouldn't even tolerate white women, and so on and so on and so on, it goes on. And I write a bit about marriages which are non-Christian, whatever the hell that means, and so on. So in many ways, apartheid was exclusionary, not only in the race sense, just one layer, in multiple, terrains and sites. And I thought the common law ought to bow undoubtedly to the new values. And the Constitution says so. You guys did a good job in writing that up. But I don't think the resistance continued all the time. When we picked on cases from the SCA and from the High Court sometimes, largely would be because there would be not even a mention of the Constitution whatsoever on a matter that the Constitution covers. So yes, the resistance has been the pushback, fight back kind of thing within the judiciary, and I worry about that in the book, as you see, as you know. We had hope, I'd hope it will be a transformative constitution. So did Carl Clare, so did you, so did people like Kathy Albertine, Pius Langa, and many others. And we thought that it would cascade from the top, hence the establishment of a constitutional court was to ensure that. And remember, I draw attention to the mistake of having a two-headed animal. And when the Supreme Court of Appeal had as much authority as a constitutional court.
You've written this book very carefully in all, because the remarkable part about it, I do want to raise one or two issues with you, but without embarrassing you, because they're in the book, but you've done it very carefully. But one of the things that you say in the book is you raise at some point section 25, the property clause, and I think quite correctly, obviously say, well, we never got a case that actually tested the limits thereof. And so I suppose the question I have for you is, I know you got into trouble by simply saying what every judge should be saying, which is, this is not a popularity contest, and it doesn't really matter what any party thinks of us. We are beholden to a constitutional system. But I suppose it's an obvious question to ask as a result of that is, I mean, there have to be limits to what the judiciary can do in relation to that particular enterprise that you're talking about. And if one's let down by the fact that there's not enough, as it were, political implementation of policy, well, then where does that leave the judiciary?
Oh, the traditional lines are plain, isn't it? We all know them. And over the years, judges were set simply to basically state the law, which already pre-exists. And the law would flow from some source. In a positivistic arrangement, that source would be Parliament. And ideally, the best of senses would be the people. We opted the other way around, to limit the extent to which the people themselves might legislate. It's quite a drastic arrangement if you think about it carefully, where we said these are the minimums which cannot be breached, even by the most popular of wills. So it was quite a carefully calibrated arrangement, not always in favor of transformation. It was also protective of past injuries, of past interests. I'm not unaware of that. But I had hoped that we would take this and convert it into something that would be quite transformative. You know that I write more, probably more about separation of powers than any of the other justices. Go look at my judgments. And that once law is encrusted, once popular will is encrusted into law, we are duty bound to follow it. It's a requirement of, it is a democratic principle. We are bound by it. So I don't propose, so in that sense, we are bound by fidelity to the law. And we ought to stay faithful to that. But where the law careers beyond the limits that we have imposed on ourselves, I think judges have to get their safety gloves on and their gumboots on and think of the TAC.
Yeah.
Ordinarily, you could decide the matter on the basis that it's a political question, a doctrine which we do not recognize, by the way. And I've been chastised for saying that.
Yes, but you were wrong to chastise for that.
Yes, I know.
Anyway,
and the reason being simply that the Constitution says any law or conduct inconsistent with the Constitution is invalid and requires the courts to say so. So it seems to me your primary task is to police compliance. And where it's absent, you're called upon to say so. But if the law is plain and straightforward, and I give you an example, like Etol's case that I wrote, where I said, no, you don't get there. Once they've decided on the method of, of raking up revenue, and the method is, there's nothing untoward about the method, we cannot impose the method we choose best, like a petrol levy or something else. So I've always been meticulous about observing the lines, but equally, particularly when it comes to rights jurisprudence, I think we've been pushing the edges quite a lot, particularly in rights jurisprudence, I think.
I think that's right. But I then wanted to ask you, because that links to something that you don't shy away from in this book, and rightly don't shy away from, is that over time, various points, the executive, to be perfectly blunt, the government, has not been very happy with the judiciary. And there have been all sorts of, you document the fact that there was a meeting which you and the Chief Justice Mogoeng were central figures in, with, I think, then President Zuma, etc., which essentially was caused by the fact that there were all these attacks on the judiciary. Do you think that we're past that now? Do you think we're in smoother waters at the moment when you reflect back on your career?
Answer, yes. I think there is a measure of, honeymoon revisited. The sense that the executive is much calmer. And I think if you think of the kind of things that occurred in the Zuma era, compared with now, it's much calmer waters. Think about them leaking documents that suggest that Justice Van Vestes and Justice Vonneman, me principally, and Thuli Madonsela are CIA spies. And are receiving dollars.
About that until you've documented it. It's unbelievable. And I think, and I'm very grateful, I'm sure readers will be, that just so I can remind the listeners that actually the letters are in your book, which is just extraordinary.
But I thought I'd put them out there because we had said to Mogoeng, look, if we are spies, and Vonneman J and Van Vestes J and myself were quite at idem, that's why we wrote one letter. If we're spies, we're ready to tender resignations. But damn, send your intelligence people to go and we knew that they would find nothing because there was nothing. And that's why I make the point. Van Vestes says, well, give me the account number. I just want the dollars in there. I'm so poor, I want to go to Cayman Island and get the dollars.
Yeah.
And nothing came out of it. And we got the Inspector General's report and he said, Moseneke is patriot number one. He loves, adores, and respects and works for this country. It's all nonsense. And I reproduced it there for you to see how far the executive sometimes went in their dirty tricks. So it was just totally uncomfortable. And that's why at the time, Chief Justice Mogoeng attracted attention also. He was pilloried just as hard as I was, and the rest of the bench was. And I mean, in the Western Cape, you didn't escape the criticism either. You were thought as an unfriendly jurisdiction, and so on. So, and what about Gauteng? I mean, Mlambo and them, al-Bashir judgments, and all. In fact, at one point, the High Court did far more weightlifting than the Constitutional Court.
Yeah.
Yeah, because the High Court judges really were the, with the damn wall, and they were out there, and we had to come much later, much lightly, to say, of course, they are correct, and so on. So I'm grateful for that and all our colleagues, but the executive now has gone much calmer. And we've had battles. I mean, in that meeting, I won't go to any details, and I don't in the book, but in the end, we told them basically, no, nothing's going to change. And we had all the JP, and you were there too, Dennis. I don't know if you attended the meeting, but you were at the meeting where we planned how to deal with this thing. And it was lovely to see all the leaders of the court argue them that we have to tell the executive that they shouldn't do this, and that we're going to do our work, and we at the height of our sincerity. We have no crooks here trying to vie for political power. We're doing and we're pronouncing as we understand the Constitution to permit. And that, I think we won that round. But it's much calmer now, I think.
I think that's right. But what does intrigue me, and I just interested in your view, is that the executive certainly seems to be behaving quite, as you rightly say, if I could put the word, as constitutionalists in that sense, which doesn't entirely surprise me, given who's in charge. But it does seem to me that judges, particularly in the Gauteng court, get really kind of viciously attacked on social media by various populists in certain judgments, which is kind of, I think, quite deeply disturbing. And I suppose there's, from your, just from your experience, there's very little one can do about that, I suppose. You just have to accept that's now what social media does.
Yes, and I think the executive could play a much more beneficial role in that regard. If they said, we don't agree with everything that judges do, but they have a job. We don't agree with every law they make, do we? Or every policy decision they make. But there are careful bounds there. It's very rare where judges will career into, deep policy-making terrain. It's very rare. Certainly, executially, almost, very rarely. They could actually continue to say that the judicial function is a legitimate function. I'm equally worried about the public protector. It's fine to pillory the current public protector gratuitously, but let's think about it. Our biggest downfall in the last 25 years has been a gradual hollowing out of institutions. And outside of executive political power, nobody else matters. And the courts then on the other end are supposed to be the only other place where, and that's why the courts are flooded. So we're going to have to take a couple of steps back and rebuild those institutions. And the executive can make a difference. And the social media tide might turn a little because they come in mainly in politically sensitive cases. If the courts have made an error about, I don't know what, maybe gender justice, you won't find quite, or access to retrovirus, you're not going to find the same type of vitriol as comes from party apparatchiks. So that still worries me that it is a bit of a rearguard action.
I wanted to ask, well, let me just come to something. I need to treat this cautiously because you've treated it cautiously, and I would in any event cautiously. I don't want to talk about the Schlorpy case, although you've set it all out and you say to the reader, well, you judge for yourself. It's all there. But you did make a remark, which I think is a legitimate one and which concerns people, which is that a complaint that was lodged literally 12 years ago is still up in the air. And whilst I don't want to talk about the merits of that, I do want to ask you as to why you think it is that consistently we as the judiciary have not handled these kind of high-profile controversial complaints with speed and getting rid of them as quickly as we can. Is this a flaw in the JSC Act? Is it something that we could cure? Because surely these things should not drag on. They should be done relatively speedily, because it's to the advantage of everybody, including the judge against whom the complaint has been lodged.
Indeed, indeed. You know, not so long ago, George Bernard Shaw wrote about something called professional protectionism. People of the same ilk tend to just, form a lager around one of them who might run into trouble. They almost do it instinctively. You remember, try and sue one doctor and get a few doctors to testify about professional negligence. You almost can't get any. No. Even if they were right there at the same operating table, you're not going to find too many going out there to try and hold one of their own to account. That's the one explanation. The other, there's developed a pattern amongst judges to basically run rings around the system. And I'll talk about the system and its structure. It has horrific defects. But almost all of them, I said one time as chair of the conduct committee, and I'll explain why it was so, because it was so defectively constructed and legislated. The Chief Justice could not do it because he chaired the JSC. And the work of the conduct committee had to be kicked upstairs to the JSC for JSC to make decisions. So he would be always conflicted, almost inevitably would be conflicted. So the end result was that I had to do the work here so that he can sit there up there. And that way it's not conflicted. But the Act is a horrific piece of legislation. It needs to be redone, relooked, and cleaned up immediately. Everything gets kicked up to the big body, the JSC. And there, of course, then the power play comes into, gains traction, because you have so many people who sit in there. And if there's any political tilt in the one way or the other, and then, of course, nothing or little might happen. So in those 10 years when President Zuma was there and holding sway, I don't think there were too many people who were eager to be seen to be advancing perhaps this case and a few other cases. So people would stroll around it and skirt around it. The JPs too, who met often, would skirt around the case. So nobody really truly got down to knuckle down. As did the earlier JSC of George Bezos and Thomas Moroka, and that lot were very active. They actually had the initial hearings, if you remember.
Yes, I do.
Those were stalled for a number of procedural reasons. So to wrap it up, we have a defective legislation. It does not, once the initial complaint has been filed and the initial processes, the decision has to be made whether this is an impeachable conduct or conduct which would merit less than impeachment. If it's less than impeachment, it basically runs into the cracks, and you get a warning and the thing goes away. And that tends to go quicker. If it's a potential impeachment, I said in a number of hearings, a number of initial hearings about failure to write judgments, about which I was thoroughly impatient. Judges are there only to do one thing, to write judgments. Hear cases and write judgments. That's your job, none other. So if it didn't happen, I always took the view that I thought it was an impeachable offense. It was gross misconduct. And none of those really made their way I made series of findings like that, but none of them really found their way to the top. As you know, nobody has been impeached ever, or at least brought to a tribunal to explain himself or herself. So judges have to really change their ways themselves and honor the code and try and demand prompt justice, as I say in the book. And we have to do something, because that was raised repeatedly in our meeting with the executive.
Yeah.
You can't corral your own.
That's the point. It's a good point. I wanted to ask you, because we're moving to the end. After you retired, you did the Estee Dumani inquiry. And it's a kind of full circle for me in a way, because there you were as a 14-year-old, and there's a wonderful description in the book about your first encounter in court with Judge Lee, which is both tragic and funny, if I may say so. And there you come, you leave your judicial office and you do this unbelievably gut-wrenching inquiry. And I wondered, as you were sitting there, whether you thought, my goodness, is this a dream? Or, from the moment I was on Robben Island to now, surely my society has got to a point where this should never happen in a democratic society. And what do you put it down to, that there could be such callous disregard for life?
Total deep depravity. Look, Marikana had preceded that, remember?
Yes.
And having the PAC as my alma mater, and think of Sharpeville, the whole notion of people just being shot down like they were in 1960 by the police without recourse and without justice after that. Nobody was held to account for anything. They shot people, they died, and club. Next. And there we were, Marikana. I remember that morning, and just the pain and the agony. I was seeing it actually happen, and as it unfolded. Then comes Estee Dumani, and I'm asked by the family. Section 27 and the family pick a judge, and they say to the government, this is the judge we want to hear this thing. And the provincial government says, okay, yeah, this is the judge that we'll have too. So at least they were agreed about who the arbitrator should be. And therefore you have to get the facts to be able to do the arbitration. And the parties preferred an arbitration because they wanted an outcome that would be compensatory. A mere commission of inquiry would fizzle out into findings which would gather dust. So at least we had that cooperation at that level. But Dennis, it was unbelievable. It hurt like you don't know. And, on occasion, I cried personally. It was just so hurtful, so gut-wrenching. I would hardly control the tears that would come running. I mean, think about this. Many of them die, circumstances you had in the evidence. They don't, because they didn't tell anybody where they're taking them to, they didn't know where to take the corpses to. They stuffed the corpses in some hospital mortuaries. Now, lo and behold, classical incompetent state. The mortuaries are not cool enough, and the bodies decompose. Why? And I insist, I want people to come and give evidence. What happened to more? Because the people come there looking for their beloved ones, and they're in a decomposed state, Dennis. I mean, on top of all of that, and then the pain of running into your loved one who's decomposed, whose body is decomposed. No, this senior did not order the gas, and they did not call the technician to connect the gas, so the mortuary can be at a certain temperature, and yet they put bodies in there. Now there are many bodies, of course, many people have died, and the bodies went rotten. I mean, after all of that, and look at that, a horrific example of a dysfunctional state. Yeah. Can't even keep a mortuary going. So many things just bubbled up to the surface, Dennis. You talk about 1990. I mean, my going to prison, fighting for this, coming back. Yes, it was a massive disappointment. And
I appreciate that. And it, in a sense, it kind of takes the book full circle. I'm running out of time, so relatively in the interview. I did learn one other thing. I learned many things in this book, but the one thing I learned as well was many of us, and I mean no disrespect to two people who became Chief Justices. It's not about them at all. But many, and I think Judge Cameron mentions this in his introduction to your book, that many of us had sort of compared you to Oliver Dene Schreiner, who never became the Chief Justice. But actually, we didn't realize that in your case, unlike his, this had occurred 3 times. And that perhaps that's the way to end, to say, I think it was a great tragedy that at some point you did not lead our judiciary organizationally, although there's no question if you read this book, you did do so intellectually. And the interesting point that you make is we're a strange bunch, judges. It doesn't matter if you're the Chief Justice or you're a Constitutional Court judge or any other judge, you have one vote. It's just your voice. And your voice has certainly been heard very loudly and very eloquently. And may I just recommend to everybody that they buy your book, All Rise, a judicial memoir. They'll learn a hell of a lot. Dikgang, thank you very, very much.
Thank you for having me, dear colleague. I appreciate this. It was a privilege talking to you.
Yeah, take care.